the skills you need for facing the interview or viva voce. Okay, they call it a viva voce, but actually it is an interview. Now, uh, when you are organizing a team for a match, first you have to see the pitch conditions. Okay, the pitch conditions for this viva voice is the composition of the panel. Question that you should have in mind is that who is going to interview you? Right? This is the first question you need to ask yourself. I have no control over the trademark registry. I really do not know who are going to be the members of the interview panel. Okay? I am making this caveat before I start the lecture. But I know in the past, whenever they have conducted such interview, they will have one deputy registrar. They will have one academic who is teaching trademark law. And they will also have one more person, namely a practicing professional. 3 members normally constitute the interview panel. Okay. 1 person from the department, 1 person from the academic, and 1 person from the profession. Okay. I mean, this is the expected composition. I don't know if they have changed the rules and the government can, in its wisdom, take a decision. This time we'll have all people from the department, fine. That is also quite possible. Okay. This is something that you normally expect actually. Okay. But surely the departmental representative is going to play an important role. Okay, that is something that, and you are not going to know who is the departmental representative and who is the academic and who is the practicing lawyer actually. So, but this is the normal composition. Right, that is about the composition. 2. What is the expected duration of the interview of each candidate? This is the next question that you should ask when you face an interview panel. I have just checked up from the net and found there are 4 centers. Okay. And there is one online panel. Right. You can opt for either a personal viva voice at the center or an online panel. They have identified just 1 day for the interview. And they have notified 196 candidates who they will be interviewing or doing the viva voice. Right? 195 candidates. So, 5 panels, 195 candidates. So per panel, they are going to do something like 40 candidates. Okay. Now, let me go into further questions. Okay. How are they going to do it? The next thing that you should know is that the interview panel is going to commence their sitting at 9:30. And they will probably go on till 5:30. Yes, Purnima, you have joined. Gioli had joined. Whoever, there is some, what do you call? Please mute the mics actually, please, yeah? Alright, yeah. Okay. Now coming back, 5 panels, 196 candidates.
Yes, sir, I have joined. Sorry, I was not able to hear you.
Can you mute your, okay, I'm fine. Don't worry here. Whatever I am speaking, I have made a word file. At least if you come on the video, I will be able to do a bit of lip reading and gauge what you are speaking. If you close and say I am not able to hear you, I don't think I could do much about it actually, but whatever I can do it actually, okay. At least if you show your face and speak, I can try some lip reading skills, okay? Because I am short of hearing, I probably will be able to do that also actually. That's not a problem. Huh? Okay, now let me come back. 4 panels, 196 candidates. 5 panels, 196 candidates. So each panel is going to interview about 40 people. Right? And now let me further analyze that they are going to have something like 6 hours, 9:30 to 1 o'clock and 2 o'clock to 5 o'clock. That is the normal expected time. Beyond that they may not work also, government servants. But things have become tougher for them these days, okay. So probably they will extend that actually. So when you look at all these calculations, okay, each candidate is going to get something like 10 to 15 minutes for the viva, okay. This is I'm just talking about the logistics and the preparation and all that. Now, there are 2 things actually. First, what are they going to test in the viva voice or interview? In the normal course, if I am an examiner or interviewer, I know that you have already been tested on the statutory provisions and the rules. Okay? You have written an examination. Only those people who have been declared as qualified or called for the interview. So, very, very unlikely they are going to ask substantive questions during the interview. Mind you, it is only unlikely. I am not saying that they will not ask, they should not ask, because it's not in my, domain to tell them, but I have been in the panel sometime earlier for the patent agent examination, and sometimes I officiate as an interview member in some other panel, and this is what we normally do. In any case, you have written, I think, 4-hour or 5-hour examination. 4-hour examination, right? So, if they have to test your substantive knowledge of the trademark law, they have already done it, okay? Now what they are expected to do is soft skill and application provisions, okay? You are going to get into trademark law practice. And they have already tested your knowledge of knowledge and understanding of the Trademark Act and rules. So what, if I were in the panel, I would like to test the soft skills and the application skills. This is what the interview board members are expected to do. Now let us understand the type of professional work you are expected to do. After you become a trademark agent, what do you do here? First is you have to wait for work, unless you are already employed, where there is a lot of work actually, okay. I declared myself as an IP counsel and waited full 2 years for finding some work actually. Of course, it doesn't mean that I was totally unemployed. I was taking bail, getting people evicted, recovering money for them, conducting trials in criminal courts, all kinds of work. Okay. Now, so what is the type of work that you are expected to do once you become a trademark agent? I will classify this into 3 categories. First work is registration work here. Most of us are going to be involved in registration.
He told me he will return the money.
In terms of the revenue, most of the revenue for the professional comes from registration. If you ask me how interesting Yeah, Purnima, can you mute? That's what somebody had said that, And if it is possible, come on the line and speak to me on sign language if you don't comprehend what I am speaking. Now I'll try to comprehend you actually. All right. Fine. What is the work you are expected to do? And what soft skills you are expected to have for being a trademark agent? First work is registration work here. Okay. Let me tell you very honestly, I'm not really a good guy in registration. You understand? I'm a litigator and teacher and researcher, and in fact, most of the registration work in all the big IP law firms are done by paralegal. Only thing you are going to say is what is the clause, whether there is an absolute ground for prohibition of the registration of the mark. I am not even going to bother about the relative grounds because somebody else is going to do a search. And if there are search results that indicate that there are similar marks, as a lawyer, we will still take a chance. Only when the application is refused, we can file an appeal. For registration, you have to charge low. Because, let me tell you, there have been a lot of online advertisement for trademark registration. People are doing it for as low as 1,000 rupees here. And I find that the registration work, and if you are going to do 20 registrations per day, fine here, you get the economy of scales. And if I am going to spend about 2 or 3 hours searching and 1 hour finding the absolute ground, relative ground, statutory provisions prohibiting registration and all that, unless I get about 20 registrations a day, okay, registration is not a very delightful proposition for me, okay. If the registration is refused, I am in. If there is going to be an opposition, I am in. If there is going to be a rectification, I am in. If there is going to be an infringement, I am in. If there is going to be a commercialization and trademark evaluation, I am in. You understand what I am saying? So, the point I am trying to tell you is registration work. Now, I want you to have an idea of, so first work is registration work. Then the next work is compliance work. Okay. What is this compliance work? You lodge registration, and thereafter the trademark registry looks for the so-called formality check. Now the scope for the formality check is substantially minimal. You are going to fill it online. If there is going to be a problem in your form filling, the website itself is not going to accept it, isn't it? Yeah? Okay, so the likely for, but sometimes recently I realized I wrote the wrong date in my check and the check got bounced. You understand? So even the formality check is very, very important actually. All right. Then what happens? You understand the different stages. What is the next stage? Rashmi, you can give me a reply. After I make an application, I'm not hearing you. Sminu?
We can amend form, sir.
Huh?
We can correct that error through amendment, sir.
No. Okay. You are now jumping one stage in between. I'm glad I asked you that question. The next stage is the trademark office will issue what is known as a first examination report. After you make an application, after you comply with the requirements of the formality check, if all formalities have been effectively complied with, the trademark office will issue what is known as a first examination report. In that report, they will tell you whether there is an absolute ground for prohibition of registration, whether there is a relative ground, all that actually. So there will be some communication. This is the second stage where you will be interacting with the trademark office as a professional. First is filling the form. Second, let me again confess, the last time I wrote a response to the first examination report was 20 years ago. Okay. Okay, let me talk to you my disabilities also. When I come in the position where I promised to transfer you all the skill and knowledge, all right. But I have a feel of it, and I have done it when I was a young professional, and according to Thiruvalluvar, if I know something and if I had known that properly, what I have known will stay with me for 7 janmas. Okay. So therefore, I take the liberty and feel confident to tell you how you should respond to the objections of the first examination report. These guys may not ask all this question again. Let me tell you that, okay. Now the next stage is what? I am able to comply with the requirements of the trademark office. What is the next stage? Yes, Rashmi? I think Sminu had answered my previous question. Bhuwana? Pramodini?
Acceptance or opposition.
Oh no, 1 minute. Again you are jumping, two you are putting together. Okay, don't do 2 stages together. Next is acceptance of the application for advertisement. That is the third stage. Let us understand stage by stage. Like pregnancy, you have the first trimester, second trimester, third trimester, right? So there are stages in everything actually, okay? And it has a gestation period, and the trademark application also has all that actually. Okay, let us go back. The next stage is, during the first examination report, in order for you to comply with some of the objections, you may have to carry out amendments. So now you look at what is the amendment, and again what is the form, what is the fee, what are the requirements contemplated. The one simple question is that, what is the procedure for what I call as carrying out amendment? Again, there is something called a voluntary amendment, which you want to do on your own. And there is something called an involuntary amendment, which the examiner tells you, unless you carry out this amendment, I am not going to allow your application. You understand? This is involuntary. Normally, involuntary amendments are not chargeable. You are not doing it. You are doing it because you are compelled to do it. But suppose you want to do a voluntary amendment. For example, the applicant has died. You want to put in the name of, so he will tell you, okay, whatever, the applicant may have changed his status from a partnership company or an individual. He may have become what is known as a private limited company actually, okay. So it will involve something. And again, see, what do you mention in the application? Be very, very sure about it. First thing you mention is your name and address. The second thing you mention is the type of goods. And the third thing you mention is the period of use. Okay. And the fourth thing you mention is address of service. These are the essential parts. Name and address, type of goods, classification, in which class you are seeking the application, and then period of use. In terms of period of use, okay, I always advise people that they should have, even when they fill the application, regarding, for example, if I were in the panel, one question I will ask you is, what is the effect of misrepresentation in claiming period of use? This is actually a difficult question. Don't worry. I hope you don't get examiners who ask you difficult questions. As an interviewing panelist, I am interested in knowing what you know. I am not interested in knowing your ignorance, because I know that I have my own quota of abundant ignorance on several aspects of anything that I do. Okay, but that's okay. We will try to do it by okay. Now, this is one type of a compliance work. Here at this stage, in response to the first examination report, you may have to carry out certain amendments. Okay. Now you pick up the skills of amendment and look what is the form, what is the fee. Okay, this is one question they may ask you. In fact, they should not yet. Because when you go on to the net, everything is available. Okay, alright, that is the next type of work. Then comes, Rashmi, as you said, advertisement. Okay. After advertisement, you have what? After that, just now you said Rashmi. Someone else can give me an answer? Huh?
Opposition.
Lodging of opposition. In lodging of opposition, again, there are two aspects. One, opposition lodging within the time prescribed. No questions asked. Okay. And one more thing is that, you know, what the trademark office rules tell you is that if you want to lodge an opposition, you must, beyond that time, you must file a form, get the form lodged even before the period is over. Okay. Actually, it is wrong. You understand? Huh? If you challenge that in a court of law will say, once the legislature has given you a grace period, you as an implementing authority must take a point of view which will give the benefit of that section and rules to the people. You can't put one more condition and deny them the right and say, yes, you have time under the statute or under the... in the rules we have said that you ought to have lodged this form before the expiry of the period. You didn't do it. Therefore, I am not allowing it. If they do it, you should be happy if the client is willing to pay, because you can file an appeal on this ground itself. All right. So, opposition within the prescribed period, opposition beyond the prescribed period. But again, you know, period is about 3 months and 2 months, right? I'm not too sure actually. Okay. Don't worry. Luckily I don't have to take the interview at this point of time. Huh? How much is it? 3 months?
4 months.
4 months plus 2 months or 1 month? Is it 3 plus 1 or 4 plus 2?
3 plus 1.
3 plus 1. Okay, Kinnari is giving me an answer and thanks for that. And what is the form for opposition?
TMO.
Okay, right. And now the forms have changed. Unfortunately, I realized that my book is 1997 and I realized it when I was talking about the different forms for application. Fine, that's okay. Now you go on to the net and you know, you find everything, and I'm not wanting to bother with a lot of unnecessary information that takes space in the brain actually. Okay. Very limited space is there, right? Alright. Let's cut that loose talk out. And the next stage after opposition is what? Please remember, one more consequence is that opposition is lodged. Opposition is conducted, regular proceeding, okay? Evidence in support of the opposition and reply to the opposition and rejoinder to the opposition. And most importantly, one more question I will ask here is, to Kinnari this time, is a hearing before conclusion of opposition mandatory?
Yes. If
Not re-
both the parties,
Parties who seek a hearing must demand it actually.
yes, yes.
Isn't it? It's not a matter of right. In a court, you take this for granted actually. Because the trademark proceeding is a quasi-judicial proceeding actually. You understand? What they have to do is to hear the other side. If we have completed the essential documentation, the trademark registry is expected to pass an order based on the documentation available. Hearing is not mandatory. If you want a hearing, you should ask for it. Okay. This is the soft skill that you learn to pick up while dealing with the trademark office. If you had expected a hearing and if these fellows have not given you, there is nothing much you can do about it. Of course, you can challenge it in an appeal and things like that if your client is willing to pay you for. Okay, so that's fine. And the next work is opposition. And if you carry out a major amendment after the opposition, sometimes you may have to carry out amendments even after the period of opposition. Okay, even after that. So again, sometimes there will be a re-advertisement. Okay, let me not go into all those. Okay, then if the opposition ends in your favor, you get what is known as a trademark registration. With this, your registration work is over. This is the first part of the work. What is the next part of the work? I think I covered it during my lectures actually. Second part of the work that the trademark professional is expected to do. What is that? Compliance work. First work is registration work. Next work is compliance work. For example, what do you mean by compliance work? When I am having a trademark, I may transfer the trademark to somebody else. Under the Trademark Act and rules, any transfer of a trademark has to be in a written agreement, and the written agreement must be lodged with the registrar of trademark, and the changes in ownership has to be documented in the trademark register. In this transfer again, there are three types of transfer work. One is transmission. What is transmission? I make an application, I die, my legal heirs get themselves entered as the legal heir. This is simple, no question is asked. And the second is assignment. Then the third is registered user. Okay, this is when you are talking about the compliance work, there are these transmission which occur due to the operation of law. I am a private limited company, I merge myself with another private limited company, and that company becomes the owner. So this is transmission. Second is assignment. Assignment is a situation, somebody may ask you a question, what is the difference between transmission, assignment and registered user? Okay, these are all relatively difficult questions. I asked you all that actually. Any clue? Sudarkodi, Buena, Dipali. I just want to keep checking whether you are there. Sorry. Bad one, That's what I did as a student, You are there physically present in the class and mentally you are off. Anyway, I'm just kidding. Don't worry. Okay, assignment. Assignment is a situation where the trademark owner transfers everything to the recipient. Whereas in register, the assignment can be for a period. Assignment can be for a territory. Okay? It need not assignment till the happening of an event. Okay? when a trademark owner does an assignment, thereafter, normally he doesn't have any rights. And the third situation is registered user. Actually, earlier in 1900 and all that, usually when a trademark is licensed, okay, that's a situation which will come under the category of a registered user. I retain the ownership, okay, and I tell the licensee, give him permission to use the trademark for a period of 5 years, right? In respect of the Indian, Sri Lankan, Bangladesh and Pakistani territories. This will be the next type of a registered user agreement, and in which case each of the agreement has to be registered with the respective trademark offices actually. And sometimes what you have to do is some states impose a stamp duty on the assignment agreement. If you are going to show any consideration, you have to fulfill the requirements of the local stamp duty. Okay. Some states have a what I call liberal provision. Some states are very strict. Bombay and all, they look at it as a revenue earning proposition because more big companies, more trademarks are being assigned. Okay. So what I will do is, if the owner of the trademark is in Maharashtra and if the recipient is in Kerala or Madhya Pradesh, those states have not realized that there is money to be made in this. Chhattisgarh, Sikkim, right? Yeah? Now, if you are going to comply with the stamp duty requirements in that state, it's possible if there is a connection. I mean, these are all complicated, what I know as a hair-splitting professional situations, which I'm sure you will do, but it may not be necessary at this point of time. So it's again, this is where you as a professional have a role to play. You have to reduce the cost so that you can take it for yourself. And then tell the guy, hey, only because you paid me, I saved you so much money. And he may not grumble that if he is a normal guy. You understand what I am saying? If I am going to save that guy $100, and nothing wrong if I take away about 20, 30, depending on the type of work that I do. Sometimes I take 60% if I have to spend too much of time on that actually. Alright, now let me cut that part out. And the third work is enforcement and commercialization work. Let me tell you, the trademark registry should not be bothered about it. You may not get any questions because they don't do this. But they are interested in what is known as the registration work as well as the compliance work. Alright. We have seen the process of registration and then, alright, then how do they conduct interviews? This is again, let me tell you, I am a teacher here, okay. I am also a lawyer and I am a freelance researcher, blogger or whatever it is. And the most subjective thing or most subjective method of evaluation I have seen is this viva voce interview. So I always tell people, be on time, don't be dressed outlandishly, right? Don't irritate the people, okay? Sometimes we do all that, we end up doing all that, okay? At least I have occasionally, for various reasons. Don't fall into their provocations, and they are in a position of authority. And let me tell you, there is a lot of I don't know how many marks are for the interview here, any idea?
50 marks.
And your viva was a written examination?
200 marks.
So, okay, so luckily for us now, earlier it used to be 50-50 here. if you have done well in your what I call as if you had got say about 130 in the written exam, right? Have you been given your scores in the written exam? They don't, that is their problem. This is the problem. This is where what I call as the interview board's discretion come into play. And let me tell you, lot of people, I'm not saying they abuse their discretion. They end up making mistakes in exercising their discretionary powers. Let me put it as mildly as I can. Okay. Luckily for you, 200 is for the exam and 50 is for the interview. So, and even the interview board, they have to maintain some, and please remember, this conduct of interview is an executive act involving exercise of discretion. Under law and Indian Constitution, every executive act is subject to judicial review. Don't argue all this with the examiner, for heaven's sake. I am only educating you about the rights you have. Suppose you score 150 marks in your exam out of 200 and the interview panel gives you 10 marks. I could see that this is a clear case of abuse. You understand what I am saying? There must be some correlation. Or you chose to ask them, then I'll talk to you about the type of questions they are going to ask. Now what I'm trying to tell you is to give you the soft skills to face the interview. I have written a detailed notes and I'm going to circulate it, and I'm not going to overshoot the time. I just have about 18 minutes from now on to complete it. Now, the thing is, unless there are very serious irregularities and mismatch between what you score in the written test, and in fact I believe that all of us have a right to know, okay, how much we scored in the written test. I mean, they should tell you at least after the end of the examination. If they don't do it, demand it. You understand what I am saying? These guys are just doing it, say they have, last exam was in 2001 or 2 or 5 or whatever, I don't know actually. At least the patent office conducts examinations quite regularly. The trademark office has just begun the process, and it is a trial and error for them also. All human institutions are not perfect, and I am not going to accuse the trademark office. I may have to go and appear before them, and all right. Now, so the thing is, make sure that there is something called a reasonable match between what you score in the written test. And one more question which I definitely expect is, this is a standard question here. What is the difference between trademark infringement and passing off cause of action? I have covered it, okay, in detail. I have circulated detailed PowerPoints in addition to the lecture. Look through all the PowerPoints before you go for the interview. All right. Now, the next thing that I want you to appreciate is that how I have conducted the interview. So therefore, I'll tell you how we do it. We have to do about 50 persons in a day. And unless I ask the same questions to all the participants, I may not be able to objectively evaluate. So what we all will do is, but at the same time I have only 10 minutes, right? In the 10 minutes, I can take only 2 minutes for 1 minute or 3 minutes for questioning you. Okay? Give you 7 minutes to give you an answer. But sometimes the interviewing panel will give you a lecture and then realize that the time allotted to you is over. It can happen, you understand. But nowadays we can be very sure that all the interviews are recorded here. Okay? Everybody knows then it involves a lot of discretion. In fact, if you want to challenge the award of mark in the interview, you can demand the video of it under the Right to Information Act. But don't worry, I am not willing to complicate your interview experience, and I don't want us to be seen as quarrelsome, cantankerous professionals. We must be friendly, and you understand what I am saying. We can be sarcastic, we can be assertive, right? But at the same time, let me tell you that, so what do these guys do? When I come and sit with the other members, hey, these are the 10 questions or 15 questions, standard questions. But first Minu is coming, next Rashmi is coming, third Sudarkodi is coming, fourth Bhuwana is coming, and fifth Kinnari is coming. So 1, 2, 3 to Minu, 4, 5, 6 to Ganesh, and 5, 6, 7, 7, 8, 9, or 8, whatever, 7, 8, 9 to Bhuwana, and 10, 11, 12 to Sudarkodi. So it will look as if I have not repeated the questions, but at the end of it, when the fifth fellow comes, we will go back to the whole. That is the correct way also. You understand? We are subjecting all of you to the same set of questions, and based on the answers you give, at least that's how I would like to guide my interview panel when they put questions. Give them mark based on what that each, there are differentials, right? You will miss 1 point, you will miss 1 point, you will merge 2 points, you will jump from 1 point to the point 3 by missing 2 points. Based on these kind of subtle differences, you are going to award differing marks to differing people. So I like you to be with certain amount. Okay, now one more aspect. They ask you a question, you give an answer. Now let me assume the question will be 1.5 minutes. Your answer should not be more than 3 minutes. And I have also told you that the best test for wisdom is, okay, your ability to say things sharp. And the more you talk, the more mistakes you are likely to make. That is what I have realized with people actually, okay? So try to be sharp and don't use expressions like I guess, I believe, it should be like that. That means even you are not very sure about what you are saying. You understand what I am saying? Huh? Be sure, clear, and don't think that we talk to our subordinate, right? Where we want to keep for ourselves sufficient scope for interpretation to cover up our mistakes, okay? Don't ever do that in an interview. Okay? Straight away, right or wrong, finish, over. And if your question is blatantly wrong, only then, okay, all right, one question is gone, doesn't matter. We still have about 40, 30. Let me 3 questions. This is what is the normal pattern. I don't know what is going to be your interview board. Because they are going to have only 10 minutes for each person, right? So they can't be giving a lecture on trademark law and find out whether you qualify for an award of PhD. That's not the business at all here actually. Okay? Right. So you can expect a supplementary question only when you answer your first question well. You understand what I am saying? If you make a blatant mistake in answering all the questions, well, they don't give you 0 here for sure. Huh? Everybody has spent their time, effort, money, right? So some minimum will be there actually. So don't be too bothered. After all, it is only what I call as 20% of the marks actually. Okay? So don't use don't have to cover up anything. You understand? Don't use expressions like I guess, maybe, it looks, all these things are strict no in an interview. Make a mistake, doesn't matter. Be forthright. Make the mistake fastest so that you can go to the next question and cover up your mistake and So make the interviewing panelist realize you are not all that bad as I thought that you would be. Okay, all right. Now, so what I told you is that they have a question bank, 15 questions or 20 questions. From that 15 or 20 questions, they are going to repeat. So it is not unusual for the other candidates. After you finish the interview, someone will come and ask you, hey, what did they ask you? Huh? Please do tell them. You understand what I'm saying? You know, he's a fellow professional like you, right? And you can, if you are going to be the person next to me, there is no point in asking that question. If you are going to be the person 5 or 6 ahead of me, it's quite possible they ask you the same question that they asked to that person. I'm just trying to tell you here. And unless they think, but my problem, which I will not like as an interviewing member is, if you are going to ask different questions to different people, the real problem will be some questions will be easy and some questions will be tough. The persons who face the tough questions will be suffering injustice, which should not happen. You understand? That is an improper exercise of executive powers. All right. Now, that's it, and I have just about, I'm almost done with that, 7:22. I have identified A to L. I'm going to send this to you as part of the group circulating material. First is the overall position of trademark system under the umbrella of IPR. This is one area normally you all neglect here. Okay. After all, you know how many IPRs are there, Minu? How many IPR?
Trademarks, patents, copyrights, designs.
That's all?
Yeah, that GI.
You belong to my generation, okay? Why?
That biodiversity.
No, that's a wrong name. Plant varieties protection. Don't worry. Go ahead. Yeah, tell me. Yeah. This is actually a mock. So this is an area you need to concentrate, and I have sent you the first PPT is on everything about IPR, where I have identified when I was a student, there were only 8. Okay. Now there are 8. In another 4 or 5 years' time, it will become 12. You understand? In pharma, new IPRs are being demanded and being got. Have you heard of orphan drug protection? But it's not a patent law, so therefore I skip it actually. Alright. Then data exclusivity, pediatric exclusivity, and in patent I'm talking about. The new IPRs are okay. So I have given you what is known as everything about IPR PPT. Have a look at it. That is the overall position of, because if you are talking about IPR, trademark is just one aspect of it. And I have always try to put in the class that you should take what is known as a comprehensive approach to the protection of IPR. For example, my phone. What is the most important component in my phone? What is it here? Yes, Rashmi?
SIM card.
Yes, somebody, I think Kinnari gave me that, what they call as a motherboard, right? Motherboard, right?
Yes, sir.
What is that protected under? Chip.
Semiconductor device.
Semiconductor chip, you understand? So there are patent, trademark, copyright, design, plant varieties protection, semiconductor chips, right? And there are other forms also actually, okay? Pediatric exclusivity, what I call as the data exclusivity, Hatch-Waxman. Don't worry, that is not part of the game for you now, but understand the other IPR and take what is known as a comprehensive approach for the protection of IPR. This is one area. See, you don't know what questions they are going to ask you here. The next area is interrelationship and distinction between trademark and design. Copyright and design. What are the differences? What are the commonalities? Then trademark and design, trademark and copyright, trademark and geographical indicators. You understand? For a geographical indicator infringement, then the common action, the action is common. Okay, misrepresentation, right? So what are the commonalities? It's all there by and large in my PPTs and the lectures. And third, registrability of marks and grounds of our refusal. What are the absolute grounds? What are the relative grounds? What are the situations in which even the so-called absolute grounds are not all that absolute? Four, this is again important. I expect definitely a question on this. Distinction between certification trademark, collective trademark, normal trademark. Okay. This is something I've covered it in the course and syllabi, blah blah blah. Then difference between trademark infringement and a cause of action based on passing off, which I mentioned just now. Then criminal remedies available under trademark law. And what is known as a minimum mandatory sentence. When can you put TM? When can you put R? Okay. TM you can put when you apply. Or you can put only when the process of registration is complete. But you may have taken a copyright registration, and when you put it after your brand, you are misleading that it is a trademark registration. This is actually a criminal offense. Okay. But for this only the registrar can initiate proceedings actually. Okay. Not everyone can initiate proceedings. Then there is a concept of this minimum mandatory sentence. Okay. Actually, these people shouldn't ask here, but the lawyers will ask you. If there is a lawyer in the panel, right? He will ask questions from his area. What do you understand by the minimum mandatory sentence? That is, once the judge holds you guilty of infringement, he must give you 3 months, okay, 6 months, okay. And if you are a repeat offender, enhanced penalty. Look at that criminal remedies, and it's there, I think, between section 95 to 112. I don't even remember the section. All right. Then this is very, very important. Have an idea and just quickly Google and look through this WTO TRIPS agreement, Wikipedia, and I have also given it in my notes and things like that actually, okay. Salient features of the Paris Convention, Lisbon Treaty, NICE classification, Madrid Protocol. These are all sure questions actually, okay. International registration. Is it possible for making one application and get a registration valid for different countries? The law is very clear. You have to make the first application, and you have to make and that application must result in a grant in the host country. After it is granted, within a 3-year period, you can file for what is known as a Madrid registration. Then opposition and rectification proceedings. And they will ask one question, whether CPC is applicable, CRPC is applicable, Indian Evidence Act is applicable. If there are lawyers who are in the panel will ask you all these questions. And for them you should give an answer. Look here, Trademark Act is a self-contained legislation. Meaning, it prescribes a procedure and formality. And once you comply with the provisions of natural justice, all these CPC, CRPC, Evidence Act are only directory and not mandatory. Then, what if the trademark registry makes a mistake? That is what I call as the oversight and the appellate provisions, okay, under the Trademark Act. When an appeal is available, within how many days you should file? Earlier we were filing these appeals to the IPAB. Now you are filing the appeals to where? Who has appellate jurisdiction?
High Court.
High Court, very good. That's the answer. All right here. And finally, look at the recent report of the IPR office, go to the trademark section, have some quick look at the number of TM applications filed, number of grants, number of opposition, and number of rectification proceedings. Okay, at least you can impress, and that's all about it. And there are questions, and I am forwarding this write-up. I think that runs up to about 5 pages. I'll forward it to you. All the very best. This is not really part of the package, but if I have to run an extra mile for you to be a success in the profession, I'll be glad to do it. I'm sure all of you will do it. And about the people who have not cleared in the exam, don't bother here. Let me tell you, these guys can be weird. Okay? They just fail people just to make sure that they have evaluated stuff. And if you had written the exam well, and if you think that they have not evaluated it properly, ask for the evaluated answer script here. You understand? Huh? You have a right to demand that actually. Alright, don't worry. And it's just that, and sometimes, there are various biases in whatever. Okay. Now, I don't want to wash the dirty linens in public about how the trademark office functions. And I guess I am done with the day. Okay. We began 5 minutes late and I am finishing 3 minutes ahead. If you have any comments or questions, we'll be delighted to take it.
I wanted to know what is the situation where you go for a registered user?
A registered user, see, firstly there must be a written agreement. Okay. Secondly, you mentioned the duration. Thirdly, what are the measures of the quality control? For example, when I say quality control, quality control means when you buy a McDonald's in United States of America and buy the same McDonald's in Bangalore or Chennai, it must taste the same. This is what I call as a trademark is a commercial certificate on the origin of good. So for the trademark owner to ensure, they are called as franchisees, right? The franchisees are expected to follow certain standard operating procedures, right? And there must be some information on that, and that's it here, okay? Form and the prescribed fee, look at it, that's what I'm saying. Each stage you are looking at it in the next 2 days. Look at the form, look at the fee, okay? And
so if I am a
yes.
owner, say Tamil Nadu only, but my franchises are also in Tamil Nadu. Those franchises also I have to make them as registered users.
Yes. See, it depends on the relationship you have with the franchisees. You understand what I am saying? Huh? You should, for example, if you are in the soft drink business, first thing is water treatment. Next is the sugar. Cane sugar is different, beet sugar is different, unrefined sugar is different, and the third thing is the essence. Okay. That depends on the facts and situation of each case. But if the trademark owner is in Tamil Nadu, that brings me to the next question. What is the official language of the trademark office here? Any clue? This will be one question I'll ask you. Everybody will be tempted to say Hindi. It is not. The official language for the trademark office is English. If you want, you can use Hindi. In which case you have to provide translation. And mind you, providing translation for patent will cost you more money Then, anyway, these are jokes. But please, Udarkudi, I will think that, wait for the franchise agreement to go on. You understand, for a reasonable period of time. You have to register it actually, registered user, if there is a quality control measure, okay. The trademark owner must demonstrate that all the franchisees comply with the minimum condition. But please do ask me questions, and I am going to send you a list of questions also, and I am sure that all of you have work at home. If you have questions, read it today, get back to me tomorrow. I'll try to respond all the questions even more. All the very best, everybody. So, Mahalakshmi, shall I dismiss the class?
Thank you for accepting the participants' invitation and
No,
conducting the
it's
class
good.
once again for
I'm glad you asked for it, and I hope your time was well spent today. Eh? Roshni, I think you are the one who demanded that first, right? You had spent that 1 hour, which is not exactly part of the agenda, but nevertheless I thought that, I will try to transmit the so-called soft skills and the peculiarities of the interviewing process so that you will do well actually. All right, yeah. Yes, thank you Mahalakshmi for making this happen, and I wish you all success. Those who have missed it, the bus here, don't worry. Take it again, and sometimes the trademark office makes it a point to fail you to check how sincere you are in your efforts to become a trademark agent. So take the exam again, and all the very best.